All right, welcome everybody. This is the call to order for the Chesapeake Beach Board of Appeals, 7 p.m. October 30, 2023. We'll begin with a roll call. Please answer in the affirmative. Mr. Richard Birch. Here. Mr. Paul Doherty.
Present.
Ms. Amy Everett.
Present.
Mr. Stephen Sharp.
Present.
I am Mr. Jody Hoonstar. We have a full house tonight. So we will start with the approval of minutes from the past meetings. I will do all three of these at once. So we are considering the approval of the minutes of September 19, 2023, the Board of Appeals case 2023-03 for Rod and Reels Incorporated, Donovan Estates LLC. That's number one. Number two, approval of the minutes for October 16, 2023, the Board of Appeals special meeting. And number three, the approval of minutes for October 16th, 2023, the Board of Appeals closed session. Does any member of the board have issues with the minutes as they received them? Hearing none, I will entertain a motion to approve the minutes.
I so move.
We have a second? All right, all in favor?
Aye.
Approved. We will start today with some procedural matters for this case for 2023-03 Rod and Reel Incorporated, Donovan Estates. For this session and the next meetings, we will be limiting our time to 2-hour sessions today and going forward. We have another planned session for this same case that will begin November 8th at 7 p.m. And at this point, I believe we need to pass it by motion. So I will I'll entertain a motion to have 2-hour sessions for this particular case.
I will make that motion.
Second?
Second.
Thank you. Pass. Okay. A little bit of administrative business. Yes. Motion to continue. Okay. In that case, I will hear a motion to continue this meeting on the 8th of November.
I will make that motion.
Second? All right, all in favor?
Aye.
All right. Now, for this case, during our last session, we need to clarify a bit about the order of presentation. We'll be following the standard order presentation as documented in the Board of Appeals Rules of Procedure Attachment A from here on. Since we are resuming from the meeting on 9/19, this is as follows. We'll begin with 1, appellant testimony and evidence, including witnesses, which will be followed by town staff testimony and evidence. And then after that will be testimony and evidence by a person or entity whose rights are impacted by the appeal, members of the public, if you so choose to speak. And we will wrap up with any summary statements, at which point we will close the public hearing and begin deliberation. One additional note on a different topic, please do direct all comments and questions to the board chair or legal counsel. This is for the petitioner and staff, and also applies to the gallery. Please do not direct questions at the petitioner or his staff. Finally, a note for the gallery. Documents were submitted to the board in hard copy form during the previous session. These documents are available on ChesapeakeBeachMaryland.gov on the page for the notice of public hearing for the Town of Chesapeake Beach Board of Appeals, posted October 26th. At the bottom next to the bold text that's for applicant exhibits, you'll find a link to all the evidence we have on hand. If any additional documents or evidence is to be presented, please submit it to the town in advance of the public hearing so it can be made available for the gallery, or provide extra copies, which I understand has been done today. Okay, so any other procedural items that the board would like to discuss before we get into it? All right, hearing none. This is the Board of Appeals continuation, case 2023-03, Rod and Reel Incorporated, Donovan Estates LLC, to consider an application from Rod and Reel and Donovan of 4160 Mears Avenue, Chesapeake Beach, Maryland, for a decision on interpretation or alleged error to Article 6, Section 290.23, 290.31A1 and 6 of the Chesapeake Beach Zoning Ordinance, and C390, C310, and C311 of the Chesapeake Beach Town Charter. Applicants request the Chesapeake Beach Zoning Board of Appeals to order the zoning administrator and planning and zoning commission to immediately commence and prioritize the processing and review of the relevant site plans submitted by Rod and Reel Donovan, and that the zoning administrator and planning and zoning commission be ordered to apply the zoning ordinances in effect as of January 29, 2021, when the applications were submitted, and for such other and further relief as the nature of their cause requires. At this point, I will pass it to Mr. Blitz for a continuation of his presentation.
Thank you, Mr. Chair. Eric Blitz on behalf of the Rod and Reel. If we could, BJ, if we could start I have a PowerPoint just to help both the public and the board perhaps follow along. And I just got to make sure I don't go too fast. So briefly, to summarize where we are in our presentation, the Rod and Reel filed 5 Category 1 site plans on January 29th to the Planning and Zoning Commission. Site plans are required of property owners to develop their property, mandatory statutory obligation of the Planning Commission to review site plans, mandatory statutory obligation of the zoning administrator to assist the Planning and Zoning Commission in the review of those site plans, and the review by the commission has a 60-day deadline after the filing of the application for the site plans. That's required by Maryland statute. And then we presented evidence on February 5th. The zoning administrator sent an email to the Rod and Reel agent giving notice of 2 reasons why the site plans would not be reviewed. That's on Exhibit 7. The first reason was that 5 applications imposed a significant challenge to the commission and the town's planning, zoning, and project review functions because it would delay and derail the commission's work on ongoing comprehensive plan update. And the second reason was notice of a February 24th meeting or a hearing scheduled by the commission to recommend to the town council adopt an ordinance to impose a temporary moratorium on the processing of site plans, including the Rod and Reel's 5 site plans. We also showed why the comprehensive plan was already 4 years late at that time, and the statutory obligation of the town's zoning code mandating the commission conduct a review of the comprehensive plan every 6 years meant that the commission was supposed to have been done in 2017. And we pointed out that Maryland provides an additional legal requirement of 10 years for comprehensive plan review, which meant that at this point, the commission hadn't met that obligation either. And Maryland does allow 2 6-month extensions, but the commission did not make those requests. And there's a consequence to the failure to meet Maryland's deadline, and that is, under Maryland statute, it's illegal to make any changes to zoning classifications. So we then submitted the commission, the minutes of the commission, that big packet of all of the minutes from 2018 to 2021, where we showed the zoning administrator during that period of time, the Planning and Zoning Commission during that time was working on the comprehensive plan at the same time they were working on the other site plan reviews. So that's where we are right now. For our next step, I think it's important for the board to understand the dual duties of a Planning and Zoning Commission. So it has 2 different types of duties. One is in the area of planning and policy, and that's associated with the comprehensive plan, and that's quasi-legislative. We don't get to challenge what the plan actually is. It was very, very hard to challenge it. Let's put it that way. The other are the administrative duties. I don't know whether I'm close enough to the mic so people can hear me, so I'll try to get a little closer. Which includes recommendations to the town council, site plan reviews, subdivision and plat reviews under the subdivision regulations. And under Maryland law, they must do those concurrently. There's no statutory authority in the town code or Maryland law that allows the commission to prioritize one over the other. At the time of the Rod and Reel's application for site plan review, were filed in January of 2021. The commission had been working on the comprehensive plan and the administrative duties on site plan requests for almost 3 years, including some major site plan reviews. Yet a mere 7 days after the Rod and Reel filed its applications, there was a moratorium being proposed to prevent my client's site plan review from going forward. Please consider the statutory and important role of comprehensive plan in the town zoning authority because it's relevant to the rod and reels applications and the commission's long overdue plan. A comprehensive plan undertakes the integration of a whole set of data for existing development patterns with things like infrastructure, population growth rates, the plans for the future, and makes recommendations. And each time the comprehensive plan is updated, they're looking at the current plan, those patterns, and making adjustments. But when a comprehensive plan is passed, it becomes the legal basis upon which the zoning ordinances implementing the plan are passed by the town. It gives guidance to citizens, property owners, and stakeholders about the potential restrictions of their property rights. And that's one reason it has to be updated regularly. As I mentioned before, in Chesapeake Beach, it has to be done every 6 years. And this is a quote from the land use article, section 3201, that reinforces that point about comprehensive plans, that it gives guidance to public and private actions. And that guidance is important because people are then relying upon that plan being done expeditiously. So the other thing that was mentioned in the zoning administrator's email saying they weren't going to review the site plans was this idea of a moratorium. And from that email, there is no doubt that it was targeting the rod and reel applications. You'll see evidence tonight that reinforces that point. There was no evidence that a moratorium was being publicly discussed prior to the rod and reels applications. So, and you will see that there's information in the minutes that make it clear that they were directly targeting the particular property. One small but important point is that Mr. Jakubiak's email of February 5th gives notice of what would be the correct manner of implementing a moratorium if the town council decided to implement one, which would be through an ordinance. So now I'm going to submit, which I believe, Sharon, is Exhibit 11.
That's fine. Mr. Chair, it's one thing is I think Mr. Blitz did give a brief summary as what he found to be the history and background here. Can I have a few minutes to say, well, the places that he either incorrectly stated as to what this history and why we're here, or what he did not state as to the reasons why we're here based on the other testimony?
Not right now. You're welcome to object, but the presentation has wide latitude to give their version of testimony right now. You are granted time after he is finished.
Thank you.
So Exhibit 11 is the public notice of the meeting of the commission on February 24th. As you can see, it was published on February 5th and 19th, according to the schedule at the bottom of 2021. And what I want you to focus on is a couple things. In that notice, they made clear that the moratorium was going to be temporary. They proposed in this notice a 9-month moratorium. That the moratorium was to make distinctions between which developments would be impacted. In this case, in this notice, it said those proposing 4 or fewer dwelling units would not be impacted. And it was also clear from this notice that the moratorium was to allow the completion of the comprehensive plan and the implementing ordinances. As we go forward, I'm going to be reinforcing that point a lot because when we get to the end, you'll see why it matters. So the recommendation for the moratorium came from the commission and was made to the mayor and town council. And the commission only has the authority to propose such laws to the town council that affect zoning and the subdivision powers of the town, which are then passed through the town council through ordinances. Next, I would like to submit the agenda for February 24th, 2021 meeting of the Planning and Zoning Commission, which would be Exhibit 12. And the board should recognize that on the subsequent pages after the minutes, that it includes the formal resolution proposed at that time, at the time of the agenda, of what the moratorium resolution would be. So it's got, in your binder, you've got a copy of this. And so it's got the resolution. And the reason I'm pointing that out is the subsequent minutes don't have a final copy of the resolution. So the only way you're going to know it, what the final version of the resolution by the commission was, is to look at what they introduced and then the minutes of what they say they changed.
Just for my clarification, are these documents being offered into evidence, or are they just being
Yes.
presented? Okay. Then I'm going to be objecting to both of those documents introduced at that time.
Overruled.
Okay, so you can see on this exhibit that the agenda attached has that full resolution. And there are a few key points that I want to bring your attention to with respect to this exhibit. As introduced, the motion was to ask the town council for an ordinance to impose a moratorium that would end at the earlier of either the town council's adoption of the new comprehensive plan and the implementing ordinances, most notably amendments to the zoning ordinance and zoning map, or the expiration of 12 months from the date the moratorium becomes effective. So it was an alternate. One could happen faster if they completed the thing, but at a maximum, it was to last 12 months. The motion itself indicates that the moratorium would be temporary and proposed that it would have a defined duration to be limited to that 12 months. Now, there's really no explanation at the hearing or in the minutes of why their legal notice said the proposal was for 9 months, but when you came to do it was 12 months. I don't think it really matters, but I'm just saying that there's no real explanation for why, when they proposed it at the commission level, it was different than the legal notice. So I'm directing your attention to the 4th and 5th whereas clauses in this, because it recites the commission's purposes and the reasons for passing their resolution, which is, remember, is a recommendation to the town council. The commission is identifying the rod and reels applications and using the two rationales provided by the zoning administrator, which is in your Exhibit 7, which was the February 5th, 2021 email. It makes it clear that the purpose.
And I can appreciate, and as Mr. Boats knows, whereas clauses are not part of the resolution. They are introductory clauses. They are not meant to be part of the testimony. They are not meant to be part of the resolution. And so they really are nothing but introductory, and they're really irrelevant. But I can appreciate the fact that of what's, trying to be asserted here. But, I can appreciate what Mr. Blitz is trying to do here. But, at the same time, whereas clauses simply are not part of the document itself.
Is that an objection?
Yes.
Okay. Overruled. It's entirely fine to be admitted into evidence. It has been admitted into evidence. Please continue.
And it's important for me to just let you all know that the resolution itself at the end adopts the whereas clauses as being incorporated in as part of the resolution. So it made it clear that the purpose of the moratorium was to halt the rod and reel applications so that they could complete their work on the comprehensive plan and implementing ordinances. The draft resolution being proposed recognized another important legal proposition, which I'm going to explain now. In the fourth paragraph of the whereas clause, it reads, whereas adoption of zoning ordinances, plan development ordinances and regulations, subdivision ordinances and regulations, and other land use ordinances and regulations, shall be consistent with the comprehensive plan. And that's basically quoting from a statutory provision of Maryland law, which is section 3-30B. I'm pointing that out because that's an accurate representation of what is referred to as the consistency requirement. And that's that the town's zoning ordinances must be consistent with the comprehensive plan. It makes all those zoning ordinances dependent upon having a valid, and some would say internally consistent, non-ambiguous and understandable comprehensive plan before imposing the zoning ordinance limitations on property rights. There used to be a legal question about whether a comprehensive plan was more of a planning document or more like a law, required but kind of itself not separately enforceable. And it comes up in your special exception cases that the board can hear. In 2008, the Maryland Court of Appeals, now called the Maryland Supreme Court, found that a comprehensive plan was not binding in a special exception case in the context of it's a somewhat famous case in Maryland called Terrapin Run, for the purpose of Mr. Sussman. I'm sure he probably knows it, but it's 403 Maryland 574. The legislative reaction to that case was quick and immediate. What they did was change the law so that the comprehensive plan was had the legal status of a law. The reason that's important in this case is twofold. Because zoning ordinances must be consistent with the comprehensive plan, as they are dependent on the plan for validity, the only way any town zoning laws that are applicable to a property in town, including the Rod and Reel's 5 properties, for site plan review, is the amendments to the comprehensive plan that were being considered by the commission in 2021 to be adopted be implemented in what are known as implementing ordinances. And so it's important to recognize that they had to do both. They recognized it in their recommendation to the town council, and that they had to do it within 12 months. The other reason that it's important in this case that you recognize that a comprehensive plan has the status of a law is that it must be prepared and adopted according to the town charter, the Maryland zoning law, and the procedural requirements of the zoning code, which would include the requirement that the update be adopted at least every 6 years, but also that any change to the legal requirements for processing site plans under the zoning ordinance has to be adopted by substantive legislation, which requires passage of an ordinance and not merely a resolution. The proposed resolution for the moratorium attached to the minutes also makes it clear that it was not all site plan reviews that were being prevented by the moratorium. It was only some of them. In the motion itself, in the agenda, it accepts out certain properties and development activities that are of record, and they cite the grandfathering clauses of your town code in sections 245.6 and 245.7, as well as minor reviews for the applicability, excluding minor reviews from the applicability of the moratorium. This is important because it introduces a legal distinction in the availability of site plans for property owners that is not made by the existing zoning ordinance, which requires review of all submitted applications. Remember, we went over the command language of the site plan in your zoning code. To make that distinction in the context of zoning, the substantive law is being changed, and therefore it is a law of general applicability and effect, which we're going to demonstrate tonight, that requires the passage of an ordinance. So now I'm going to submit Exhibit 13, which is our February 12th, 2021 report to the mayor and town council from Larry Brown, who was the chairman of the Planning and Zoning Commission.
And just procedurally, I'm objecting to that also, please.
Apologize, Mr. Pounds. Can you say that one more time?
I'll be objecting to that document also. Thank you.
Overruled.
So on page 2 of that report, in the second to last paragraph, what I'm pointing out is that the commission is going to consider the moratorium at its upcoming February meeting. So this is a report prior to the resolution and the meeting of the Planning and Zoning Commission to the town council. The chairman's reporting on this page 2, that the commission is going to consider a moratorium at its upcoming February meeting, that it would be temporary, it says it right there, to end when the work on the comprehensive plan was finished or the expiration of 12 months, whichever occurs first. And it also reinforces the point that they're directing this towards the 5 site plans that had been filed by the rod and reel. Now, as part of the testimony on that subject before the commission, I submitted a detailed letter to the Planning and Zoning Commission, which made a part of their record on behalf of the rod and reel, which I'll offer as Exhibit 14. That's my letter dated February 23rd, 2021, which commission one day before their February 24th hearing on the moratorium resolution. So I'm not going to go over the details of such a long letter. I'm just going to get in some of the key points. I recognize it's a relatively long letter. While I encourage you to, the board, to read this and all other evidence carefully when considering the case during your deliberations, I think it's best in this context just for me to point out what I think is important relative to the narrative we're going through right now. So in that letter, I put forth my client's arguments to the commission against the moratorium. I described how it was specifically targeting the rod and reel's 5 site plans, which had already been filed, and at that time were required to be reviewed by that commission by March 30th of 2021. That's in the first paragraph and the third paragraph on page 2. How it was unjust to my client to have, because all 5 projects had not only been previously permitted in the past or had various stages of site plan approvals already, these 2021 proposals were substantially the same, including Harbor Vista South, which had been approved by the commission as late as 2016. And that's in the last paragraph of page 3. And that the comprehensive plans of the town for its entire history with zoning since 1972 called for exactly these kind of developments on these properties. That's covered in pages 4 through 8. I described that the plan existing at the time in 2021, and which the commission was seeking to amend through its update, had literally recognized the pendency of the anticipated development of these 5 site plans. They were called for in the prior comprehensive plan. They're referred to as part of their calculations. And finally, I listed all the site work and mitigation that had already been done on these projects under the previous permits and the detrimental reliance of the rod and reel on all the past comprehensive plans. So at the hearing before the commission, they had notice of these problems, as did the town council, who was copied on that letter. And they held their meeting on February 24th, and I'll submit the minutes to reflect what occurred in that meeting. So that's Exhibit 15, which is the minutes of the February 24, 2021 minutes of the Planning and Zoning Commission.
Continuing objection, Mr. Chair.
Overruled.
Couple points that I'd like to make about these minutes. So this is from the relevant paragraph. Chairman Brown introduced the motion for the moratorium, saying they were recommending that the mayor and town council adopt a temporary moratorium. So that the temporary part was reinforced. Now, during the debate, this is the part of the minutes that reflect the debate and the motions on that resolution. There was a motion by Commissioner Evans to amend the resolution to reflect a 9-month moratorium instead of a 12-month. Remember, it's kind of the earlier of finishing the comprehensive plan and the zoning ordinances and this outer limit duration. He was trying to move the outer limit duration to 9 months. That motion failed, though. And that's relevant because the duration of the proposed moratorium was a matter of debate by the commission and, as you'll see, by the town council. So it establishes that the moratorium as proposed to the Planning and Zoning Commission was for an established duration. It was not of an indefinite duration. Now, that resolution was eventually adopted as proposed by the commission. It had a couple of adjustments to whereas clauses that you can find in the minutes. They're not relevant to our case, but I just wanted to let you know that there was those kind of changes made. There's another change that's made through the proposal, which were a little bit at variance with what was originally published as notice and described by Chairman Brown in his report. And that's the scope of which properties would be affected. It was amended during the debate on the resolution. Commissioner Greengold moved to exempt any project currently in the development approval system, which has received development plan or plat approval for the commission from the commission. This was made from a request of Mike Repke for Ridgefield Station, and that amendment was approved. The reason I point that out is it demonstrates the differential treatment of site plan review, and that's a substantive change to the effect of the town's zoning laws, which would require an ordinance to pass. So at the end of the hearing, the proposed resolution of the Planning and Zoning Commission passed on a vote of 4-1. I'd like to offer 3 documents at once, and then I'll go over their important, or actually 4. It's exhibits 16 through 19. And let me read them off what they are for the record. 16 would be the minutes of the Town Council informational work session of March 8th, 2021. 17 would be a press release issued by the town, by Holly Wall, the town administrator. The 18 would be a report from Holly Wall to the town mayor and town council on the moratorium dated March 11th, 2021. And 19 would be the town's meeting agenda for March 18th, 2021. So
417.
17 was a press release issued by the town on the moratorium. Dated March 11th, 2021. So that would be 16, 17, 18, and 19.
And we do object to all of them.
Overruled.
18 and 19. Somewhere I got out of order.
Okay. I just handed her to us. 18 is the memorandum from Holly Wall to the mayor and town council about the moratorium. That's dated March 11th, 2021. And 19 is the town meeting agenda for March 18th, 2021.
Thank you.
Okay, so Exhibit 16, I'd like to point out, again, reinforcing, they said it would be a temporary 12-month moratorium, applying only to Category 1 projects, Category 1 site plans. What's interesting about this is the first instance where there's a formal distinction between Category 1 and Category 2 site plans as it was introduced, because the commission's motion and resolution to the town council didn't use that distinction. So this is a resolution being offered to the town council, a slight variance to what the commission offered, but it's doing essentially the same thing. It's making the distinction based upon site plan categories. Exhibit 17 was the press release. Again, I'm reinforcing that at that time it was made clear there would be a temporary pause. Category 1 and 2, Category 1 site plans with a 1-year moratorium. Exhibit 18, the report to the town by the town administrator to the town council, mayor and town council, was virtually identical to the press release. It was done on the same day. It too reinforces the moratorium was to be temporary and of 1-year duration, but includes the recommendation of the town administrator to pass the moratorium as a resolution, not as an ordinance as recommended by the Planning and Zoning Commission. And then we've got the agenda, the applicable part of the agenda of the town council of March 18th, 2021, which I offer to show you that the agenda called for the town council to consider and vote on a moratorium as a resolution. It would be resolution R21-3 as a resolution on Category 1 site development. That's on page 2 of that agenda. Now we get to the issue of why the moratorium was void from the outset, and therefore the first reason that the subsequent failure of the zoning administrator and the Planning and Zoning Commission to follow the required process and do the site plan reviews was an error under the zoning ordinance. So what I need to demonstrate to you is the important legal reasons why passing a moratorium through a resolution instead of an ordinance of the town council is not valid. And you should consider what is procedurally different in the adoption of the town council resolution in an ordinance, because it's those procedural safeguards that are required for ordinances which were being sidestepped. Remember that I established under the zoning ordinance section 290-25A 5C the requirement that the site plan must be reviewed within 60 days of the filing of the application, and that meant the deadline for the commission's hearing on those site plans, absent the moratorium, or absent a stipulation by the rod and reel, which does happen sometimes. Applicants stipulate to a longer period if they wish, but that deadline was March 30th of 2021. Under the town's charter, a resolution typically used to pass pronouncement of the council rather than laws can be effective immediately. But an ordinance, which must be used to pass substantive legislation, what is called under the law an action of general and continuing effect, is typically introduced at one town council meeting A public hearing is scheduled for the next month's meeting, and a vote is taken at that next meeting. Using a typical practice for passing a law that applies to everyone and stays in effect until it sunsets, as this 12-month period would have done, the town council would not have acted in time for that deadline of the Planning and Zoning Commission. So when the agenda was published and I learned that the moratorium on the agenda was being proposed as a resolution and not the introduction of an ordinance, I was shocked. I quickly sent a mayor to the mayor and town council complaining about the impropriety of using a resolution instead of an ordinance, which was dated and sent on March 16th, 2021 via email, 2 days before the town council meeting. And I offer that as Exhibit 20.
Again, for the record, objection.
Overruled.
As you can see from the letter, I informed the mayor and town council of, at least my opinion, that of the impropriety of passing a zoning moratorium through a simple resolution and not abiding by the procedural requirements for an ordinance as required by the town charter. And I point that out because they had notice of the potential impropriety, time to correct it, but did not do so. Because the zoning ordinance imposes a mandate on the zoning administrator and planning and zoning commission to process site plans through a specific ordinance section, a moratorium has the effect of changing the impact of the legal requirement that has the force of law. It's not merely an internal process, such as appointing a member to the Planning and Zoning Commission or to your board. It's not merely a sense of the town council like you would see in a resolution supporting a kid's choir or a fundraising drive. It impacts the effectiveness of a town law. Equally important in this case is it changes the applicability of that zoning law. It's making a distinction between who the site plan requirement applies to. In general, a resolution is not used to pass law applying to everyone, but merely a method by which the legislature expresses an opinion. And while a resolution can direct internal processes of a town administration or address temporary suspensions of processes, a mandated zoning process is not an internal administrative process. It is something that the property owners have a legal entitlement to under the Chesapeake Beach zoning ordinance, so long as the town is regulating private property rights. You'll remember how we started this whole presentation on understanding that zoning comes along and puts a burden on fundamental property rights. So next I would like to offer Exhibit 21, which is the resolution itself of the town council, or Resolution R21-3. As Exhibit 21. So that's a copy of the resolution that was passed by the town council on March 18th, 2021. Let me point out to those, except for Mr. Birch, that have your exhibits. I moved this resolution up 2 exhibits. So it's actually 2 exhibits further in your package. I just moved it up in time. But you've got it. So what I'd like to hand out now because you don't have it in your white book, and I'm providing it now, are sections C-309, 310, and 311 of the town charter. They are in your white book, Mr. Birch, but I need to give it to everybody else, and you need it too.
Mr. Bliss, this is exhibit 22.
It's not an exhibit, it's copies of the law. So it goes in your white binder for the section. You should have. So it's really just copies of the law. Because I'm going to be reviewing the effect of those three town charter sections with respect to our argument tonight. I'm going to start with section 309 of the charter. And it's our argument that if the town council wanted to pass such a zoning moratorium, it must have passed it by meeting the same requirements of an ordinance under C-309 of the town charter. To do otherwise, it bypasses the procedural protections and requirements of ordinances. And that includes, let me go to slide 17. Okay, so that's section C-309. That includes the requirement that no ordinance be passed at the same meeting at which it's introduced. Of course, the resolution doesn't have that requirement, and they did that. That it be voted upon by not less than 6 nor more than 60 days after introduction. That wasn't followed in this case. And that it become effective 20 days after passage or 7 days after the last legally required publication notice, unless it meets the standards for an emergency ordinance, which requires a separate affirmative vote of 5 of the council members, which also did not occur in this context. As importantly, a simple resolution is not subject to the veto power of the mayor that's set forth in section C-310 of the charter, or the rights of the citizens to petition that act to referendum that's in C-311. Those don't apply to resolutions. So by doing a resolution, they were taking away those two charter powers. So to bypass the charter safeguards by passing a simple resolution on a matter that I would submit is as grave and substantial that it impacts all the property owners in town is inappropriate and inconsistent with the town's charter and, as you'll see, Maryland law. Point out what's kind of obvious, but the moratorium was introduced as a resolution and it was passed as one. That is, it was not adopted according to the terms of the requirements in C-309 for an ordinance. The reason that's technically important is while sometimes a town council can pass a resolution that meets all the requirements procedurally of an ordinance and have the legislative effect. That happens, I believe, with charter amendments, might happen with annexations, but there's a couple different spots in Maryland law that for whatever reason, the General Assembly used the term resolution instead of ordinance. They still have to follow the requirements of an ordinance in their town charter. So there was no delay under the charter requirement that they be passed upon less than 6 nor more than 60 days after introduction. And that's designed to give the public and their representatives time to see what the exact legislative proposal is, but also time to prepare and provide comment. Resolution, you don't do that. You just pass it, introduce it that night and pass it. The moratorium by its terms went into effect immediately, thereby repealing the 60-day review requirement that was about to expire in another 12 days. And, instead of the 20-day passage rule under the charter, it became effective immediately. In addition, legislation as distinguished from a mere opinion of the council by resolution must be presented to the mayor for approval. And the mayor has the power under C-310, shown there, to veto an ordinance but he doesn't have that power for a resolution. It was merely a sense of the council. And he wouldn't have that if it was the town council merely directing an internal process. There's a timeline associated with that veto power, as you can see in section C310. It's defining what becomes law. To become a law after presentation of the ordinance to the mayor, it's the third sentence of C310, which reads, any ordinance approved by the mayor shall be law. Any ordinance disapproved by the mayor shall be returned to the clerk and a message stating the reasons for his disapproval. Upon receipt of any ordinance disapproved by the mayor, the clerk shall promptly deliver the ordinance and accompanying message stating the reasons for the mayor's disapproval to the members of the council. Any disapproved ordinance shall not become law unless subsequently passed by a favorable vote of 5/6 of the whole council within 35 calendar days from the time of the return of the ordinance. And if the mayor fails to return any ordinance within 6 days of its delivery, as aforesaid, it shall be deemed to be approved by him, by the mayor, and shall become law in the same manner as an ordinance signed by him. So this is just like bills in Congress or in Maryland's General Assembly. The legislature can pass a bill, but the chief executive must sign or veto, or if they just ignore it, then it becomes law automatically, or it's called a pocket veto sometimes. But the veto can then be overturned by a supermajority. Town charter provides roughly the same process. What's important in this section is that this is what converts a legislative act into a law. So while a mayor can sign that resolution as a certification of what occurred and may even support the resolution, the mayor is not given the power to veto that simple resolution. And that's why a simple resolution doesn't become law. I mentioned a few minutes ago how this area of law in zoning has a specific difference that makes it all the more important that the town follow its own charter obligations when passing a zoning moratorium. A resolution that is not passed in accordance with the requirements of an ordinance is not subject to referendum. As you can see in section 3-11, the citizens have the right to petition laws passed either approved by the mayor or if vetoed, passed over his or her veto, to then petition the law passed through an ordinance to referendum. So it's following that same process of the timeline for the mayor's veto, and it's defining it as law when you are allowed to petition it to referendum. That's in. You can read it yourself. The people reserve to themselves the power known as the referendum by petition. Then in subsection B, there's a deadline for the petition that is consistent with the timing of when a law is passed by an ordinance typically goes into effect. That rule of 20 days after signature of the mayor or over the mayor's veto, or 7 days after the last required publication. That's because only ordinances, not simple resolutions, can be taken to referendum. This is important in zoning law because there is a special protection of the referendum rights in Maryland's municipal zoning law, which is binding upon the town. I refer you to section 5-213 of the local government article of the annotated code of Maryland. And that law reads, a municipality may adopt zoning regulations subject to any right of referendum of the voters at a regular or special election as may be provided in the town charter. So the town provides a referendum in their charter. They passed a resolution to change the effect and applicability of a law, the section of the zoning code that requires site plan reviews. And they did so by avoiding the power of the citizens to take that law to referendum, a right that is required and protected by Maryland law. So zoning powers in Maryland are express powers, which means they must flow from an express authority in Maryland statutory law. And section 5213 in the subtitle on express powers grants those powers to Maryland municipalities. Furthermore, Maryland law is clear that the use of those express powers must be done by ordinance. Maryland Section 5-203, grant of express powers. In subsection A, in addition to, but not in substitution of, the powers that have already been or have been or may be granted to it, the legislative body of a municipality may exercise the express powers provided in this subtitle by adopting ordinances. Furthermore, it provides in subsection B that such an ordinance adopted by the legislative body of a municipality may not conflict with state law. So as I pointed out, Maryland law, state law, protects the right of referendum. They changed the applicability of a zoning power. That required legislation. They did so without an ordinance, and so they sidestepped and avoided the right of the rod and reel or any other citizen to take that act of the town council to referendum. So note that the delegation of zoning powers is directly tied to the passage of ordinances, not resolutions. And because it's a delegated express power and not what's called an inherent power, it must be done in strict accordance with the statutes that delegates that power. So in this case, it's clear from this section and the local government article 5213 that to protect the right of referendum in the zoning amendments, that an ordinance must have been used to change and express legislation that changes the effect and applicability of a zoning law. It's true that the town council could have passed a moratorium as an emergency ordinance, but they did not. An emergency ordinance would have changed that part of the timeline for passing legislation, but it would still require the mayor's assent or veto, and importantly, it still allows for a referendum. But a resolution does not. Also, for an emergency ordinance to pass, you need a separate vote of a supermajority, five members of the whole council to pass it. To further see the practical differences between subjects that need to be passed through an ordinance versus those that can be done by a resolution, you can note on the same night on the exhibit for March 18th, 2021 minutes, that's exhibit 22, but we haven't gotten to exhibit 22. Oh, no, it's the agenda, not the minutes. I'm sorry, that would be exhibit 19. On that same night, the town council adopted a town walkability plan by resolution.
Sorry, town what?
Town walkability plan. That plan is a guidance document without any legal effect on the citizens or property owners. On its own, it doesn't create any new mandates or obligations or amend the effect of any existing town code sections. It doesn't act as a law that limits or defines the rights of citizens, but instead acts as a policy guide. This is the kind of document that can be passed by a resolution. The moratorium resolution attempted to alter the legal rights of citizens, including those of the rod and reel, and did so
Mr. Blitz,
Yes.
Why don't we pause and take 5 minutes for everybody? We will resume after a 5-minute break.
Okay, thanks.
It'll take me 20 minutes. Oh, that works.
All the material that was on the website includes exhibit numbers.
I don't think so. I think it's is
Going through
the
and
scan is
separating all
it's
those.
just a scan.
That's it.
We have here. Yeah.
The
It
exhibits
doesn't have the
are
numbers
numbered.
on it. Does it have numbers or is it? Okay, so mine, I'll just do it from there then. I'll hold on to it too. Did you need this back? Oh, okay.
Oh, no, she photocopied that for me.
Okay. Yeah, I went through and did the whole like Wilson ball from Castaway.
Oh, I got the numbers and stuff, and then I'm like, no, you can't change the order.
I've already labeled them. Come on.
All these school supplies finally came in handy.
I ran out of Post-it notes
Me too.
before. Yeah.
No, because last time it was overwhelming.
Yeah.
Where are you? Where are you?
Yeah,
at,
sorry,
huh?
flipping through the-
Now I have to find it.
Yeah, you're gonna do a good job.
He 8 hours was the estimate last time. So it's gonna be tonight. Tonight we're doing 2. 8 hours total.
She's not prior
Yeah,
to.
we're capping it at 9. Pick up again.
Thanks.
I know. Yeah. Yeah. No. Oh, I see what you're saying. Yeah. Oh, right. Okay.
The hierarchy of what takes place first and order precedence.
Police officer here.
We'll all make your way to your seats. We can resume. Please continue when you're ready, Mr. Blitz.
So we went over the fact that we have a zoning law, it gets changed, the effect of it, as well as the general applicability, who it applies to. Makes distinctions between different parties. So these important legal principles have been addressed by the Maryland courts as well. So it's not just my interpretation. In your legal package, I provided you a copy of 2 cases that demonstrate this point. The first is Inlet Associates versus Assateague House Condominium Association. And in that case, the issue is whether, as part of a developer agreement, the quitclaim and abandonment of a public street to the developer could be accomplished by a simple resolution of the town council, in that case of Ocean City. Maryland's highest court found that it could not, and an ordinance was required. And the rationale and reasoning of the court is important to this case. Court found that while noting that an ordinance is distinctly a legislative act, the court went through prior case law in which the standard is that if a municipal action is one of general application, prescribing a new plan or policy, it is considered legislative and therefore must be accomplished by an ordinance. The court recognized the special procedural requirements like those I described of the Chesapeake Beach Charter as being unique to ordinances. And most importantly, as I explained in the distinction between the express ordinance-making powers given to municipalities, such as zoning, an express power rather than an implied, the court found that those express powers must be enacted by ordinance. Just like in our case where there's a specific zoning power that is an express power, one that protects the right of referendum in the town charter, the closing of a street had a specific provision in state municipal law that also was an express power. And so that required that disposition of the property be accomplished by an ordinance. It should also be noted that, as was mentioned in the Inlet Associates case, the reliance of the city council on the attorney's opinion or even a long pattern of conduct in enacting street closings through resolutions doesn't make it any less improper or legal or illegal for them to use a resolution instead of an ordinance. Apparently, Ocean City had been closing streets through resolutions for a long time, and that was part of their argument, that everybody was used to it, doing it that way. Some might argue that a moratorium on site plans is a temporary action and therefore not legislative because it merely suspends a process rather than amend a law. That might be true if, for example, it sought to change the process of a zoning administrator's that's in this town is posted on the town's website, which is strictly an administrative set of rules. It sets up a 6-week process of review for site plans before it goes to the required hearing. But it would not be true if it removed the obligation of the zoning administrator and planning and zoning commission to review site plans because there is already a law that makes that process mandatory, including the 60-day deadline. The specifics of the process listed on the website is entirely administrative. But the entitlement to a critical area site plan within 60 days is a mandatory process. So by attempting to use a resolution to pass a moratorium that changes the obligation of the review of the Planning and Zoning Commission to review site plans, even on a temporary basis, as long as it's longer than 60 days, it effectively renders moot the requirement that a zoning ordinance which property owners are entitled to rely upon be in effect. That 60-day notice is clearly designed to favor the prompt resolution of site plan applications. That's why it's in the law. The town council made a legislative judgment that it had to be done within 60 days. If it makes a new legislative judgment to change the effect of that, our argument is it cannot be done through a resolution, it had to be done through an ordinance. Because it changed the effect of certain developments, it grandfathered certain lots, certain properties that exempted it out from the effect of the moratorium. That's a policy judgment about the effectiveness of which site plans can go forward. And that's legislative in nature. Rod and Reel's applications had been submitted prior to the proposed moratorium, but they were suspended while others who had also previously filed were not to be impacted by the effect of the moratorium. So, two, with respect to the distinction between the treatment of Category 1 and Category category 2 site plans. That's making a legal distinction that's now at variance with the current zoning ordinance by passing a resolution. To make that distinction in a moratorium is to make that policy decision, and therefore it's legislative. In my letter to the mayor and town council warning them of the impropriety of using a resolution instead of an ordinance, I cited a case that had just been published by the Maryland Supreme Court. At that time, I believe it was still called the Maryland Court of Appeals. And that's the K. Hovnarian Homes of Maryland versus Mayor and City Council of Havre de Grace, which is also in your package. There, the Maryland Supreme Court found that an agreement with a developer that suspended a recoupment fee must be passed by an ordinance and not a mere resolution. Because like the zoning power in this case, the right of municipalities to impose fees in Maryland is also an express power, not an implied. So under the inlet case, you have to use those express powers through the passage of an ordinance, not a resolution. You may know that the fees associated with cases like this appeal are set by the mayor and town council and accomplished by passing an ordinance, not a resolution. All those fees that however much we had to pay to have this hearing, that's set by ordinance. So in the Hovnarian case, I was going to read a long quote for it, but I think it's overdoing that. It's just reinforcing the same ideas. They're making the point that the zoning power being an express power is subject to the requirement for ordinances. Then on page 1187, they say, in addition to the legislative grant of general ordinance making powers, the General Assembly has granted express ordinance making authority to municipal legislative bodies for specific types of legislative enactments outlined in Title V, Subtitle 2 of the local government article. And they cite Section 5203, which we reviewed. In addition to, but not in substitution of, the powers that have been or may be granted to it, the legislative body of a municipality may exercise the express powers provided in this subtitle by adopting ordinances. And that's their emphasis. So remember that the resolution goes into effect immediately. An ordinance takes time. And in the case of Chesapeake Beach, unless passed as an emergency ordinance, which would then identify a shorter period, the time is 20 days after the signature of the mayor or passage over the mayor's veto, or the 7-day rule after the last required publication, whichever is later. So it's a time period of later. In this case, the resolution establishing the moratorium by its terms went into effect immediately, but that's at odds with the 10-day requirement after hearings that is found in Maryland law. I'm going to refer you to section 4-203 of the land use article. This section of Maryland law directs the procedure for passing a zoning regulation or a boundary change. It requires a hearing and allow public comment. It requires publication. So when the town council attempted to pass a moratorium which changed the legal effect of section 290-23 of the zoning ordinance, the council did the first two requirements of subsection B that you can read there. Though perhaps without a special public hearing, they might have not completely complied, but I want to focus your attention on subsection B3. That's the 10-day requirement that I'm referring to. So this section requires after that hearing that the zoning regulations may not become effective until 10 days after the hearing or hearings. That this town's council's resolution does not do because it went into effect immediately. When passing an ordinance in the normal course, it wouldn't really matter because ordinances go into effect way after the 10-day rule. So it'd be 20 days well after. So It really doesn't come up that often when you're passing an ordinance, but it does come up and get violated when you pass it by a resolution. So I'll just finish this topic by quoting from my March 16th, 2021 letter to the town council that made it clear that to the mayor and town council that they were notified of the procedural infirmity. And I said, quote, "The proposed moratorium is not merely a cessation of discretionary administrative proceedings, but a limitation on legal rights and property owners in Chesapeake Beach found within Maryland law and the Chesapeake Beach zoning code. Although one of the purported justifications for the proposed moratorium is to facilitate Planning and Zoning Commission's attempt to propose planning changes via the comprehensive plan process, that does not save the moratorium from the requirement that it be enacted through an ordinance, because the planning power is also an express power of municipalities in Maryland." So that's making the distinction between the implementing ordinance and the comprehensive plan, also an express power, also. And so this was affecting the site plan review for something that also has to be passed by an ordinance. So that's why the moratorium was void and without effect, and therefore an erroneous justification for the planning administrator and the zoning administrator, and Planning and Zoning Commission from undertaking the administrative act of site plan review. So this is the resolution. And I want to turn to our second count in the rod and reel application for appeal, which alleges that if the board were to disagree with our contention that the moratorium was void from the outset due to this procedural infirmity of passing it through a resolution and not an ordinance, that even after the moratorium had expired by its own terms, the rod and reel renewed its demand that site plan reviews be reviewed, and the zoning administrator and Planning and Zoning Commission continued to refuse to review site plans as required by the zoning ordinance. So you've heard me describe lots of evidence which reflected that the proposed moratorium was to end by its terms at earlier of 12 months or the completion of both the comprehensive plan and the implementing ordinances. There are all those references to the moratorium being temporary in the commission's resolution, its hearing, the attempt to amend the commission's resolution down, the moratorium down to 9 months, which failed, the press release, the reports, the agendas, and the minutes, they all make reference to this limitation of period. I'm going to submit Exhibit 22, which is the minutes of the town council meeting of March 18th, 2021.
For the record, objection.
Overruled.
So this is where the town council is considering the commission's recommendation. As part of the minutes package delivered to the town council, Chairman Brown of the Planning Commission made a report to the town council dated March 10th. And that's going to be Exhibit 23, which is dated March 10th, 2021 from Chairman Brown.
That's Exhibit 23.
Yes. So this is the section of Chairman Brown's report that I want to emphasize, and I'll quote the pertinent portion of the paragraph in that report, which reads in the second paragraph on page 1. At this February hearing, the commission heard from 15 members of the public on a motion recommending a temporary moratorium be placed on the commission's acceptance and consideration of new applications for development projects until the comprehensive plan update et al. Is completed, or 12 months, whichever occurs first. The motion for a temporary moratorium passed and was forwarded to the town council for consideration. So returning to Exhibit 22, of the town council minutes. When the resolution was introduced, it was introduced with that outer limit at 12 months. But there was a debate about that during the town council. And this is the section of those minutes on page 3, where there was an amendment that was proposed by Councilman Fink that, quote, to amend the moratorium period to 6 months. And that was seconded by Councilman Favre. The vote to amend the moratorium period to 6 months was tied with 3 votes in favor and 3 against, and the mayor then broke the tie by voting in opposition. So therefore, that motion failed. Next, the minutes reflect that the motion of Councilman Morris moved to say, well, quote, amend the 12-month moratorium period to 9 months. That was seconded by Councilman Favre, and this time the vote was 4-2 in favor. So the moratorium's maximum duration was reduced to 9 months. So what's clear from these minutes is that the town council passed the resolution, not an ordinance, at the same meeting at which it was introduced, that there was a debate about the maximum duration of the moratorium, which was settled to be 9 months. These minutes were approved by the town council meeting at their subsequent meeting on April 15th with no questions about the characterization of the moratorium vote. And I'll submit the public hearing minutes as well as public town council minutes as Exhibit 24. So that's the town council hearing minutes and town council meeting minutes of April 15th, 2021.
By April,
15th, 2021. So now I'd like to call Mr. Donovan to provide some testimony. I believe he's already been sworn, but I don't know whether you want to re-swear him or what.
Would you like to swear him?
Mr. Donovan, were you present when the oath was administered last time?
Yes, sir.
Raise your right hand.
Yes, sir.
Can you please identify yourself for the record and where you live?
Wesley Donovan, 2335 Golf Club Drive,
And what's your role with the rod and reel?
president.
And are you familiar with the fact that 5 site plan applications were filed on behalf of the rod and reel in January 29th of 2021?
Yes.
Do you know who the zoning administrator for Chesapeake Beach was in January of 2021?
Mr. Chris Jakubiak.
And did you know that at that time?
Yes.
And were you shown a copy or given a copy of the email from February 5th, 2021 from the zoning administrator? That's Exhibit 7 if you need to see it.
No, I did.
Okay. So other than the February 5th letter, after January 29th, 2021, when you filed the applications, were you ever contacted by the zoning administrator with respect to the site plans or scheduling a hearing for site plan review?
No.
Was the rod and reel ever given notice of any scheduled hearing or hearings of the Planning and Zoning Commission to conduct site plan review on the 5 applications?
No.
So other than the February 5th, 2021 email from the zoning administrator, Mr. Jakubiak, were you contacted by anyone from the town about the site plan applications?
No.
I'll show you April 13th letter to refresh your recollection.
Well, yeah, I did get this, but not to review the site plans.
Well, it's about the site plan review of the site plans, isn't it?
Well, I would say this is about the moratorium, but yeah,
Okay, you received this letter of April 13th, 2021.
correct. Yes, I did.
So let's admit that as Exhibit 25.
What is that?
That's the letter from Holly Wall County Administrator to Justice Donovan dated April 13th, 2021. The board can see in that exhibit, the town administrator is returning the fees for the site plan reviews and citing the reason as the moratorium. That's a copy of it. Due to the Category 1 site plan moratorium that was passed by Town Council on March 18th, 2021, the town will not be reviewing these projects at this time and are therefore returning the checks provided with the associated projects. So as you may have noticed in my letter of the Planning and Zoning Commission of the February 23rd, 2021, that's been previously submitted, I noted that it was very unlikely that the commission would meet its deadline under the moratorium to finish both the comprehensive plan and the implementing zoning ordinances before the year-long moratorium that was being proposed. So after this passage, did you want availability across? I didn't.
Yes. Mr. Pounds, you're welcome to cross if the witness has done his
I'm
testimony.
done having
Oh.
testified. So if you wanted to cross on what we just talked about.
Please limit it to the testimony that's been given here.
Well, I mean, so is it just going to be about the testimony he just gave?
Yes.
I mean, okay, so I'm going to be calling Mr. Donovan again based upon substantial other evidence with regard to what was not discussed in his case?
If it's not been discussed by him just now, you cannot talk about it. You're welcome to cross-examine him on the content that he has provided.
Okay.
If he should testify further, we can do this all again.
Yes, I absolutely will be doing that. So, Mr. Donovan, you were informed of the moratorium?
Was I informed?
Yes.
Well, I received this letter saying that the moratorium passed on March 18th and the town would not be reviewing the site plans.
And that's the town, right? Is that what you're understanding?
The town?
Correct. That's your understanding, sir?
Yeah.
Okay, and the town, your understanding is the town council, right?
I received this letter from Holly Wall, town administrator.
Okay, is it, I'm asking is it your understanding that Ms. Wall is the one who makes decisions with regard to the town?
I don't know what you're getting at, but the town council passes ordinances and the mayor has the right to veto or sign them into law.
Okay, so it's your understanding that indeed the town council is the one who makes decisions with regard to the town, is that correct?
Yes, sir.
Okay, and that's your understanding?
Yes.
And in essence, Ms. Wall is the one who implements those laws that is passed by the town council. Isn't that your understanding?
As the town administrator, that's my understanding that that is part of her position. Yes.
Okay, and so I just want to make sure you understand. The town, I'll make sure I'm very clear on this, and I'll make sure the record is clear. The
Sure.
town council makes decisions on behalf of the town. Isn't that your understanding?
My understanding. Yes, sir.
And let's make sure you understand, it's not you, Mr. Donovan, that makes the decisions. Is that correct?
What?
It's not you that makes the decisions on behalf of the town. Is that correct?
Definitely do not.
And Mr. Blitz can state his opinions, but it's not Mr. Blitz that makes those decisions. Is that correct?
Objection to the scope of the cross.
I'm sorry.
Please move on.
Okay. That's your understanding in essence. So when the town council makes decisions, they make decisions on behalf of the town.
Correct.
And so with regard to the decisions with regard to the moratorium, that is made by the town council.
It was correct.
And also the planning commission is the one who, in essence, implements and makes recommendations with regard to this comprehensive plan. That was your understanding also?
Yes.
Okay, and you have 5 plans. Did you submit those plans to the planning commission to review during their application process?
During the application process, I don't. You mean the comprehensive plan process?
During the comprehensive plan process, yes.
Objection to the scope of the cross. It's exceeding the scope of the direct, and I'm not sure.
He's the one
What-
who discussed the moratorium. The moratorium goes directly to exactly what the planning commission's decision was making.
He
So
read,
this goes directly to what his testimony was.
he read directly from the letter of Holly Wall. I don't know what you're getting at with respect to asking him about his understanding of zoning process or the ordinance process. He didn't testify about that.
Okay, well, they're very simple. The 5 applications, which are the subject to this hearing, did you submit those to the planning commission for their review?
You want me to answer that?
I asked the question.
One moment. We'll allow the question. Please answer. You can repeat it if you would.
You know, the 5 applications, which are the subject of this hearing, did you submit those 5 applications to the planning commission for their review?
It gets submitted to they got submitted to Chris Jakubiak as the town zoning administrator.
So you did not submit those to the planning commission?
I think what happens, and I could be incorrect, but you submit the plans to the zoning administrator. The zoning administrator then reviews those with planning and zoning.
So your testimony is you don't know?
No, his testimony was just what he said.
Okay, so so you think that you submitted to Mr. Zubiak and those plans should have gone to the planning commission? Is that your understanding?
I believe we submitted, I believe the applications are part of the exhibit. If you give me a second, I might be able to find them, but we submit site plans to the town.
That exhibit goes to Mr. Zubiak, right?
Kubiak?
Yes.
I'd have to look at who exactly they were addressed to, but I'm pretty sure that they go to Chris Jakubiak, who's the town zoning administrator, or he was at the time, rather.
And you say you believe, you testimony that you're not sure?
Am I 100% sure? No.
Okay, so Mr. Donovan, this is your applications, right?
Objection.
I mean,
They're the rod and reels applications.
yeah,
Okay, well, Rod and Reel's application. And who's the president of the Rod and Reel?
I am.
Okay. So obviously, you're the one who's ultimately in charge with things that happen with regard to the Rod and Reel?
Sure.
Okay, so basically, so your testimony is you can't testify whether those applications were submitted to the planning commission pursuant to the comprehensive plan process.
Can you repeat that?
Yes, you cannot testify that indeed those 5 applications were submitted to the planning commission pursuant to the comprehensive plan process.
Objection to the argumentative phrasing of the,
Question.
no, it isn't a question. You're asking him a negative of whether he can't say something, being argumentative to
One
make a
moment,
point.
please. Objection sustained. Let's bring this back to the testimony that was given.
Okay, now your testimony that indeed, testimony earlier that these applications were somehow approved back in 2016.
Objection. That was not part of this direct examination.
Sustained.
Okay, I will be calling Mr. Donovan again in our case.
Please continue, Mr. Blitz.
Just like to make the point that's in your zoning ordinance that applications for site plans are filed with the planning and zoning administrator for the benefit of the planning and zoning commission, which then takes those up according to a process that's all set forth in your ordinance that we reviewed in the first hearing. You don't necessarily file it directly with, you file it with the town to the planning and zoning commission. the zoning administrator's first crack at it is because his job is to review the site plan and give comment to the Planning and Zoning Commission. It was filed with the Planning and Zoning Commission. The form that you file goes to the Planning and Zoning Commission. So, I'm just looking back at where we dropped off. So I think I had ended with, I was making the point that in my letter of February 23rd, 2021, to the Planning and Zoning Commission, and that was copied to the town council, I rendered an opinion that there was almost no chance that they were going to be able to complete the comprehensive plan and the implementing zoning ordinances before a year-long moratorium. As you'll recall, they shortened it to 9 months. So after the passage of the moratorium resolution, the Planning and Zoning Commission continued its work on the comprehensive plan. And by September, it was clear that they weren't going to finish the comprehensive plan within the 9-month period that the town council had attempted to establish in the first resolution. To establish that, I'm going to submit the minutes of the town council informational work session of September 8th, 2021 as exhibits 26. As you can see from that, Mr. Jakubiak reported to the town council his view that the town's has a 9-month temporary moratorium in place, which will expire on December 18th, 2021. He reported to the commission that the commission had completed a draft of the comprehensive plan and it was set for a public hearing on November 9th, 2021. But after that hearing, the commission would still need a couple of months before giving final approval. He gave some options, but was recommending extending the moratorium for an additional 3 months. Now, for the extension request, Planning and Zoning Commission held no public hearing to make this request. They did not debate it at all, as can be discerned from any public comments, public minutes, and did not vote on a resolution to recommend that to the town council. So while the town council followed the practice of having the Planning and Zoning Commission make its recommendation for the original moratorium resolution, it did not do so for the request apparently made by the zoning administrator to extend the moratorium. At the town council meeting held on September 16th, 2021, the second resolution was considered, and that's resolution R21-8. It was also voted and introduced and voted upon at the same meeting, and which purports to extend the moratorium for 3 months, and that is exhibit 27. I apologize that I did have a slide for the minutes that showed Mr. Jakubiak's recommendation that they extend it for an additional 3 months. So this is the temporary resolution we just admitted as exhibit 27, I believe. So while this second resolution was also not an ordinance and therefore just as invalid as the first resolution, when attempting to alter the effect and applicability of a specific zoning ordinance mandating site plan reviews, What this resolution makes absolutely clear, as if it wasn't already clear with all the public previous statements that you've seen in evidence, is that the moratorium was to be temporary, not indefinite, that it had a set duration. If it didn't, there would be no reason to extend its passage by this resolution, R21-8. In the first paragraph, the council recites that the moratorium passed by resolution R21-3 was temporary, and in the second paragraph, it reads, whereas the town council has determined there is a need to extend the moratorium for the continuing reason as stated in the previous resolution for an additional 3 months. Then in the actual resolve clause, it reads, the town council has determined an additional 3 months is needed for the moratorium and hereby extends the moratorium for an additional 3 months after the time period as referred in the resolution R21-3. Therefore, it's clear that the additional 3 months was, quote, needed, and that the council was intending to extend the time period from a total of 9 months. Even more instructive is the debate on this at the town council. And now I'd like to play a video of that debate from the town council's presentation that starts at the 50-minute 12 mark and ends at the 58:29. And I believe,
Mr. Chair, I mean, obviously, you can conduct the hearing if you want to, but, first of all, all of the minutes are completely irrelevant in this case because minutes are nothing more than a document to what happened. Minutes are just a documentation as to what happened. The only thing that really matters with regard to a hearing is what the decision was. Okay, and it's great to have minutes. It's great to have a history as to what happened, and you let in all the other minutes, which are nothing more than again a documentary representation, but they don't apply to actually decisions, and that's the only thing that matters. Now he wants to have a video as to what happened during. I mean, the minutes are bad enough, but if you want to have the video, that just okay. Having a debate, great. I mean, the council has a debate. Council has a debate, once, twice a month, and there's a differences of opinions. But all that matters ultimately is what did they decide? And so that
We understand. We will still allow the video and the text documentation in. And oh, thank you.
and obviously objection.
Overruled.
He's doing it.
Then you're gonna have public comment. We only got 15 more minutes.
Let's go.
Just in Little Chesapeake Beach. Some days we do 3 and 4 a day.
Room and those who, which we did.
Is that 0?
58-29.
It was 50-12. Do we have to remove the PowerPoint so that they can see it first?
Mr. Bliss, how long does this excerpt?
8 minutes.
Okay.
Said 5012.
Yes.
Just a basic one-page history.
We'll see. Okay. All right. All right. Larry? Thank you.
Crystal clear. I have no more questions, and thank you.
Mr. Mayor, one follow-up comment.
Yes, sir.
Thank you. To follow on with Councilwoman Bodine's comment there.
This isn't the
and I'm-
right section.
Moratorium for an additional
50, there you go.
3 months. Just as a quick summary before I get to the council, the Planning Commission has submitted a request to the town council for more time to devote to the completion of the comprehensive plan. Our planning and zoning administrator briefed the town council during the recent work session. As a result of that, we have before us before the council, a resolution extending the moratorium, which is currently set to expire in December of 21 for an additional 3 months. Is there a motion to approve?
Move to approve?
Is there a second?
Second.
Okay, I'll begin discussion with Dr. Bodine.
Yeah. If you actually look at the wording, I just have 2 questions, I think. I'm fully in support of this, because it was voted upon unanimously by the Planning and Zoning Commission, so this is what they want. I'm supportive of their activities. If you look at the therefore be it resolved that, and you look at the second sentence, it says time period as reformed in the resolution R21-3. Is that like a legal thing, as reformed?
That's a typo, sorry. And I can tell you, I did make the change, and for some reason before it got sent to Holly, the change was not made.
What's the reasoning?
Well, we are now getting into the issue of whether I'm giving legal opinions, okay, or opinions with regard to the resolution, which I know it's still in the video, but legal opinions still would not be part of any evidence here. And this video is now part of the evidence here. So.
Heard. If I could be heard on the objection when he's finished.
Okay, so in essence, it was just, a typo that's being corrected. That's fine. But, any other legal opinions which just may be coming to obviously creates an issue, which probably should be redacted from the video.
So first, this is a public meeting of the town council. It's already public. It's part of the record. It's literally a public document. So if you give legal advice to the town council during an open session of the town council, it's part of the record and is part of the evidence that we can present with respect to the key issues, which I'm going to get to. Promise you, this isn't just given to you gratuitously. There's some key issues being raised in this debate in this video. So that's why I believe it should be admitted.
Well, objection, because it goes back to this is a debate. This isn't evidence. This isn't a decision by the council. This is just a discussion between the council. That's all it is. Okay, so in essence, if it's going to be admitted, there's a area of law called giving it appropriate weight, which means discussions that may or may not be, going on between council would have no weight, because it doesn't necessarily mean how they would vote. They're just talking. Okay, so in essence, having some type of discussion creates some type of evidentiary hearing or evidentiary matter for something in the future really is something that goes way, way, way out of bounds as far as what anybody could do. Okay, because this isn't a decision. This is nothing more than what they may talking or what they were thinking at the time. So
Understood. One moment, please. The objection is overruled, but the board hears the argument about the weight of what we are seeing here.
Thank you, Mr. Chair.
Please proceed.
It should be referred rather than reformed. It should have been referred. So I apologize, and I'll make that change. But yeah, that's my mistake, and I caught it, but it was made, but it did not seem to get to Holly. So sorry about that.
No problem. I just wasn't, honestly, I wasn't sure if it was like something, like a legal thing.
Nope.
Pat, do we need to do an amendment to change this to referred? If so, I would like to introduce that amendment.
I don't see any reason if you wanted to cross it out and then put a tick mark there and just put the correct word, because what matters is the signatures.
Question, how much testimony are we expecting here
8
from
minutes.
council?
8 minutes.
Is it all from Mr. Pounds? When
No.
is that going to wrap up shortly?
Yes,
Okay.
well, it goes another 4 minutes. So most of what I care about is actually the part that's coming up. All this is just kind of part of the debate. What this is all of the public debate of the town council on this resolution. That is, the resolution's introduced and the town council gets to debate. The mayor turned to Dr. Bodine first. She provided her comments. Then we had some questions to the council, but that's all part of the debate on this legislative act, or attempt at a legislative act.
So if it's not done, just handwriting it in, there's absolutely nothing wrong with doing that if you'd like to do that.
I'm
Yeah,
fine.
I don't think we need it. Any additional comments, Valerie?
Yeah, I thought you were going to talk, Pat. I'm sorry. I just wanted to, if you wanted to change it. Yeah, my other comment was one thing that came up at the work session, and you just want to make sure I understand the way it's written, is that our current moratorium that we currently have expires on December 18th. This moratorium takes effect December 19th at 12:01. And this moratorium would expire on March 19th. Is anything I said incorrect?
Well, I think it's clear no.
Todd, do I got it? I mean,
Oh yeah, no, this starts right away. There's no doubt about it.
But doesn't, it starts on December 19th, right? It's an extension.
That's right. There's
Okay.
no, there are, with this, the way I've drafted, with, excluding the typo, there is no gap.
There is no gap and it expires on March 19th.
Correct.
Got it. Thank you very much for your help.
Thank you. Charlie?
Yeah, I don't have any questions, just from a substantive standpoint. When this came before the council initially, we had a good debate about the timing of the moratorium. I was opposed to a moratorium that extended indefinitely or extended for a long period of time, not because I didn't want planning and zoning to do their work, but because I wanted to keep the comprehensive plan on the front burner, and if the moratorium had needed to be extended, it would. Now we sit here today with a very completed draft of the comprehensive plan. It would be pointless now not to extend this for another 3 months. I just don't see, I just can't imagine anyone actually making applications now, knowing what is in the comprehensive plan under the old rules, let alone becoming substantially vested in their project. But it would be pointless to not accept 3 more months as requested by the Planning and Zoning Committee, in my opinion. That's all.
Thank you, Charlie. And Larry?
Well, I'll disagree with my colleague, Mr. Fink, about it being pointless. I did not support the moratorium when we voted on it in March. Given recent discussions and reports, and as just was acknowledged a moment ago, we will not have an approved comprehensive plan in 3 months, along with the required changes in the code to support the new moratorium, or to support the new comprehensive plan. So I'm not quite sure what we're doing here. I think we're going to be, if this passes, we're going to be back at this again in March, because we won't have a new comprehensive plan and the required changes in code to support it. And I just am concerned that this just drags on and on and on. So thank you.
Thanks for your comment. Mr. Morris?
Yes. I would certainly, we certainly did have debate and pretty good discussion about this at the last work session. So anybody that's in the audience tonight that needs a little more background about the decisions tonight, I would certainly refer you to that work session. We've got a public, we've got a a public meeting scheduled in November for this. I know we're taking public comment now. I don't underestimate public comment on this either. I think that there's going to be some forces against some of the things that they're proposing. In my mind, extending the moratorium for 3 months does make sense, and it does give council, in my mind, it's going to give council the time it needs to do its part at the end of this. I'm confident that we're going to get this done first part of next year. I do not see how I could support any additional extensions of the moratorium, but in my opinion, all things considered today, I think we've got this in hand. They've been working very hard. There's a draft plan that's in front of everybody, and the public's reviewing it now. There could be some changes on the council level once it gets there, but I don't see that dragging on at all. I think we're going to vote some of that up and down, and I think I can see the finish line on this. So I'm in support of 3 months. Thank you.
Thank you, Greg. And lastly, Keith?
Yeah, thank you, Mayor. So yeah, I definitely support this. I was in favor of a 12-month moratorium to start with, and that was what was requested to do the job, and we're getting very close, and hopefully we will cross that finish line soon. Thank you.
Okay, thank you. Okay, we have a motion, we have a second. Now it's time to vote. All those in favor say aye.
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 Opposed?
No.
And the motion passes 4-1. Thank you, everybody. Next,
That's the end, correct?
Yes, it is.
At this point, we have 5 minutes left. You're welcome to that time, but be aware.
Yes, I think I can kind of close out this thing. So what is clear from the debate, the minutes, and what you've just watched is that the council believed the moratorium would expire on December 19th, 2021, that they wanted to extend the moratorium for 3 additional months. And if they passed this second resolution, it would expire on March 19th, 2022. It's also nice to see that Councilman Jaworski made the point that seemed to be ignored by everybody else on the council, that even with this 3-month extension, the moratorium would expire before the comprehensive plan and the implementing ordinances would be passed. I prepared a transcript of this. I don't know whether you want it for guidance. It's just literally the transcript of what you read. It's in your book, and if you want me to offer it as an exhibit so that you have it in the record.
Yes, put it in as good.
Okay, so that would be exhibit 29?
28.
28. And I'll submit the minutes of the town council meeting of September 16th, 2021 as exhibit 29.
Just for the record, I'm going to be objecting to both of those.
Or overruled.
Oh.
Almost.
Okay, so that is a pretty good stopping point for the next segment that will kind of wrap up why a lot of that was relevant, and we'll see you at the next hearing, I believe.
Thank you. At this point in time, I'll enter. Yes.
I know one of the things that we were told is that you would have public comment this evening.
Yes, there will not be public comment this evening. Public comment will happen.
No, that's not the way it goes.
I'm sorry, but that's the way the rules are written for this type of procedure. I'd love to tell you, and maybe I should have told you at the beginning, that public comment, you are going to have all the time you want to give public comment, but the order of operations here is that the case is presented, town staff responds, then public is allowed to address it.
So
It will not be tonight. It will probably not be next time as well. The last estimate we had was that this would be approximately 8 hours.
The thing is, the public comment has a real basic effect on what's going on here. I think a lot of time is being wasted. I don't know why this isn't being presented in front of a judge, okay? Because that's all we're hearing back here. At least that's all I'm hearing.
This
There are
was
decisions that you guys can make in regards to what he's bringing up.
This was presented. A judge has passed this back down to us for some judgment that they can then consider if it should move to that case. But the order of operations from the circuit court is that we need to come to a ruling here on this board to continue on its legal path. And this board, this is the first time we've heard anything like this, and so we're learning along with you, but we are going to follow the rules that are set up.
The same stuff that came up the 19th. I'm hearing the same thing. The 19th. I think public comment is very important in this case. I mean, I don't even know why it's going to go any further if public comment was, you were able to present it.
Public comment is entirely welcome. And I'm sorry that you can't comment during this meeting and possibly the next one and maybe the one after that. The plaintiff here is going to testify for 8 hours, right? Is that the ballpark? Six and a half hours. At the end of that,
He's going to comment for 6.5 hours.
yes, that is his presentation, his right based on what he is asking of this board here today.
It's the same stuff over and over. What are our rights?
Your rights are to testify and as the public, when it is time to receive your comments, you're welcome to give them at the stadium, and you're welcome to write to us if you'd like to deliver it in letters. We will read it out for this board at the appropriate time. We would love to have public comment, but unfortunately, there's a lot going on here, and we have to.
My public comments are directed to you, however, it is really to the Donovan family.
Unfortunately, I don't know if that's your.
I think they should drop the appeal.
We will receive your public comments with regards to this case and with regards to the 5 site plans and how the process went for that. This is not a referendum on the Donovans or other business within the town. Our scope is narrow here, which is why we're trying to understand the narrative of what happened for these past 3 or 4 years and to allow the story to be presented so that then we can understand and come to a judgment, which can then go farther in the legal realm if that is what's to happen. We will certainly take public comment. We don't mean to keep you from giving public comment. And we certainly don't want you to sit here if you feel like you're just waiting to give it. You are welcome to write it and we will read it back when it is time for public comments if you feel like this is too much of your own time spent here tonight. So I apologize.
If I was learning something new and I'm not hearing anything new. I've read the minutes. I've watched the 8-minute videos and stuff. It just seems like a real waste of time here to me.
A lot of the information.
Not just for me, but anybody else that has their opinion that they want to give on this entire fiasco.
Unfortunately, that's the prerogative of the presentation. The presentation we're receiving tonight is we want them, and they're given the chance to present first and up until its conclusion.
People that they were in the right in less than 6.5 hours, then you need to recheck what you're doing.
Thank you for your comment. You are welcome to give it in writing or when we open up public comments.
Right here it is.
At this time, I'll entertain a motion to adjourn the meeting until November 8th at 7 p.m. here in Town Hall.
Thank you.
Do I have a second?
I will make that motion.
Oh, sorry. Motion second. All in favor?
Thank you.
Thank you. We are adjourned until November 8th at 7 p.m.